Hello everybody and welcome back to the Law of Tort. In this lesson what we're going to do is take an introduction to the next major topic in our series on the Law of Tort, specifically referring to the idea of employer's liability. Now we're going to divide the next two topics into two divisional topics, but they do really overlap in a number of different ways. We're going to divide firstly employer's liability on the one hand and then vicarious liability on another. Now, the reason why is even though they do overlap and there is a lot of interrelation between the two, they are still distinctive in terms of their tortious liability that is applied. One refers to an employer's liability, the other refers to liability of individuals for actions that are outside of the employment relationship necessarily. And so as a result of which we're going to deal with these two different issues separately, and we're going to begin obviously first with employer's liability, and then specifically in this lesson taking an introduction to employer's liability. This is a new topic. We'll spend some time looking at employer's liability, and in fact this is the first topic that takes away from and we move formally to a different area of tort, which is a different tort entirely. So far we've been focusing on really and almost exclusively negligence. We spoke about negligence in relation to the establishment of a duty of care, as well as to the idea of causation and the idea of a breach of said duty of care. And for the most part, we've been focusing on this in relation to only the tort of negligence, despite the fact that causation, of course, is something that is applicable in various other instances. And it is also noted that we spoke about pure economic loss and psychiatric harm, both of which are elements which really are almost exclusively in the realm of negligence. We will get to psychiatric harm in future lessons in relation to employer liability, however. Really all of these things have been surrounding the idea of negligence as a tort. And so this series of lessons is going to start talking about all of the other torts which are of paramount importance for students of the law of tort. Employer's liability, vicarious liability, occupier's liability, nuisance, intentional torts, as well as defamation. So what actually is employer's liability? What do we mean when we talk about employer's liability? Well, within the law of tort, all employer's liability does is provide a duty of care for an employer to his/her employees. So where there is an employment relationship that exists, an employer's liability essentially gives the employer a certain duty of care towards the safeguarding of his/her employees. Generally speaking, the historical development of this tort comes out of the Industrial Revolution, where of course during the Industrial Revolution there were quite significant and quite dramatic changes to the way in which work operated, and also new dangers and new liabilities began to arise as to the nature of the work that had been taking place. More dangerous work had been taking place. There was a lot more workplace accidents owing to the quite heavy-duty industrialization and industrial work that was being done. All of which led to situations whereby there was this perception that a duty of care ought to arise between that of the employer, the person who is employing the people who are actually tasked to work in quite dangerous workplace environments. So dramatic changes, of course, also led to potentially dangerous changes. The development of this area of the law comes out of both statutory provisions within the Industrial Revolution, but it also comes out of the development in case law. So there are statutory developments, but I'm going to focus firstly on the idea of case law developing this idea of an employer's liability. One of the earliest cases in this regard is from 1938, which is of course a little bit after the beginning of the Industrial Revolution, but is the case of Wilsons and Clyde Cole versus English. This was a case that provided the basis for establishing an employer's liability in relation to their duty to their employees. It was a case which involved an accident that had taken place in a mine, a coal mine. This resulted in the death of one of the mine's employees. The employer was sued in tort, but then argued that his liability ought to be voided, and was in fact voided, owing to his delegating of responsibility to the mine manager. So really you had various different levels of hierarchy that existed within these types of mines and mining establishments and infrastructures. There was, of course, the person who owned the mine, and then they would delegate quite a lot of the responsibility for the day-to-day workings and operation of the mine to a mine manager. And so they argued that they should not be liable for the death and the damage and the accidents that occur in the mine, owing to the fact that it is actually the responsibility of the manager, rather than him specifically, to actually ensure that there is a sufficient duty of care to their employees. This argument would fail, and it would lead to the owner being liable in the law of tort for the accident which has taken place in the mine of one of his employees. The courts presented, as a result of this, a basic framework for which an employer may be liable in the law of tort for the damage that is then caused to employees. They held that the employer had both a personal duty of care to the employee, as well as a duty which cannot be delegated. So it first established that this duty of care arose, and then they established and essentially responded to the argument that was being presented by the defendant, which was that I can't be liable because I've delegated this duty to a different individual, the mine manager. They argued that this is a duty that cannot be delegated. It resides and rests fundamentally in the hands of the owner, the employer. The courts in this case found that an employer has a duty to provide a competent workforce, an adequate amount of quality of equipment, and an effective work system. So this was really answering the question, well, okay, there is a duty of care that is clearly owed from an employer to an employee, but what is this duty about? What is the duty of care? What kind of duty of care exists? Because, of course, there are certain circumstances in which, like in the instance of a mine, that there will be accidents. It's quite a dangerous working environment. Is an employer liable for each and every incident of an injury or an accident in any kind of workplace environment? No, that would be a bit silly, and that would lead to quite a significant amount of litigation. In regards to the amount of duty, the duty of care, the duty to provide what, it is a duty to provide a competent workforce, to provide an adequate amount and quality of equipment, and to have an effective work system. So this therefore establishes the common law duties under the remit of employer's liability. In the next lesson, what we'll do is get on to looking at some of the other factors that relates to employer's liability, specifically looking at the nature of an employment relationship, because of course, as time has gone on, there have been different types of employment relationships that exist, and so as a result of which, the instances in which employer's liability actually covers certain circumstances and certain relationships has had to change in response to these changes in workforce relationships. In the previous lesson, we took an introduction to the nature of employer's liability. We talked about essentially moving on from the cases of negligence and all of the key factors that are required for establishing a case of negligence, and now moving on to looking at a completely different tort. We also noted that as a result of a case involving an accident and a death in a mine from the 1930s, that there was an inherent duty of care that existed on the part of employers towards their employees. In addition to this duty of care cannot be delegated away and essentially ascribed to other individuals. In that case, the owner of the mine, the employer, actually attempted to argue that they did not have a duty of care owing to the fact that the duty of care had been delegated to the mine manager. This lesson is going to talk a little bit more about what is required as part of the duty of care of employers within employment liability. We are going to examine each of the key components within the common law which relate to this idea of an employer's duty of care to their employees. These are the key components that we noted came from the previous case, the case of the mine, which is of course Wilson's and Clyde Cole versus English. We noted in that lesson that there are three main principles and that there are three main factors which are to establish and provide the duty of care of an employee towards an employer towards an employee. These were the duty to provide a competent workforce, to provide competent and effective amounts of work equipment, and to provide an effective workplace. These are the three principles that were established in that previous case. So what do these principles mean? What kind of standards can be essentially enshrined within these principles, and what cases have been established that look to examine these principles in a bit more detail? Well, let's begin with the idea of a competent workforce. A competent workforce, the duty on the part of an employer to provide a competent workforce, is usually one which requires an employer to ensure each of their employees is able to actually perform the work that they are employed to do. So the useful illustration of how this is actually applicable can be seen in the case from 1957 of Hudson and Ridge Manufacturing Corporation Limited. In this case, we see a prank that was done on a fellow employee. The claimant was the employee who was the victim of this prank, and the defendant in this case was the employer. So an employee had performed a prank on an employee, and it was up to the defendant, who was the employer, to essentially have a duty of care to provide a competent workforce. And so the question of law in this matter related to whether or not the employer had a duty of care to ensure that other employees are kept safe at work. And so the performance of this kind of prank from one employee to another employee, which could essentially manifest a certain amount of danger and a certain amount of accident-prone injury in a particular work environment, might have given rise to liability on the part of the employer to essentially ensure that a competent workforce exists. That's what the question of law was asking. As you can imagine, this is obviously something that relates to a competent workforce issue. And so the result here was in relation to the employee. And because of the persistent behavior by this particular employee who was performing all of these different pranks on these people, the employer was found to be liable for failing to stop this behavior. So it was held in this regard, therefore, that if you have an employee who is clearly unable to perform their actions without doing any kind of prank-related activities, they would be liable. The employer would be liable for failing to stop this behavior, and so as a result of which is not only failing to provide an adequate, effective, and safe working environment, but is also failing to provide an effective and competent workforce. A further case comes in 1958, the case of Davey versus New Merton Board Mills. This case illustrates that there is a duty of an employer to provide adequate equipment at work, which is, of course, the second limb of the duty of cares as established in the previous case from the 1930s, the case of the mine accident. In this case, the employment was a toolmaker's, which had utilized defective steelworks. This was a fault in the equipment that the employer would have reasonably been expected to notice upon basic inspections of their equipment. When the equipment then broke, it led to quite a horrific injury. It led to an employee losing sight in one eye. The equipment essentially caused a blindness in the eye of an individual who was employed by the employer. Now, it was held that while there is a duty of care to provide adequate equipment, the employer was actually not liable in this case specifically because they had taken the defense of being able to take reasonable care to ensure safety to his employees. In fact, it was found that the supplier had supplied dangerous equipment. And so rather than liability being essentially imposed onto that of the employer, who had been found to have taken reasonable care to ensure the safety of their employees, it was found that the supplier had been the one supplying dangerous equipment, and so they would have been liable in the law of tort for this particular incident. Finally, then, we have this idea of providing a safe working environment. An employer must act in a way which provides a duty of care to his employees to ensure that the working environment that they are actually performing their tasks in is safe or is up to a reasonable standard. Okay, providing a safe working environment does not suggest that an individual is liable wherever there is any injury or accident or something that takes place. Inherently, some working environments are quite dangerous, and so as a result of that, there is only a minimum standard to be upheld to that would be a reasonable standard for an individual to actually perform safe working environments. This lesson is going to examine the nature of employer's liability as it relates to psychiatric harm. So we have thus far been talking about the nature of employer's liability in relation to the kind of damage that can be suffered as a result of the negligence of employers, specifically focusing on what the duty of care essentially entails for an employer: the duty to provide a competent workforce, to provide adequate equipment, and to provide a safe working environment. Of course, the cases we've so far been discussing relate more to physical injury that therefore give rise to an employer's liability. So it involved an accident in a mine, for example, that led to the death of an individual. We had one where we had various different pranks that had been performed by one employee against another employee that the employer was liable for in terms of providing a competent workforce and a safe working environment. And we also talked about the concept of certain amounts of equipment that had been faulty, that led to the failure of a piece of machinery that led to an injury of a person losing sight in one eye. Of course, this is something that all relates to physical injury in relation to employer's liability. This lesson is going to think about the ways in which psychiatric harm can actually be an applicable kind of damage in relation to employer's liability. So we have to think back to the ways in which we define psychiatric harm in the traditional tort of negligence, what psychiatric harm is, how it works, the kinds of limitations that are placed by the courts in relation to psychiatric harm. And we can conclude that there are generally two ways one can claim for psychiatric harm. The first is where there is a psychiatric harm that is the result of injury. So, i.e., we have some kind of physical injury that then suffered, there is some kind of psychiatric harm that is then suffered in conjunction with some kind of physical injury. This can relate to some kind of PTSD or some kind of relationship that is of that kind of nature, that maybe as the result of the physical injury, you develop some kind of recognized psychiatric condition. Of course, the requirement in all of these is that of a, quote, recognized psychiatric condition. And so that's obviously something that is diagnosed by medical testimony. You then also have psychiatric harm, which is considered to be pure psychiatric harm, where it is that there is no injury, physical injury that is incurred onto an individual, but that there is only psychiatric injury that is incurred onto an individual as the result of negligent action. And this can be delineated into that of a primary victim and that of a secondary victim. And we noted that essentially as you go from primary to secondary victim, the ability of and the propensity for there to be a claim that is successful reduces quite significantly. And we noted that there are various different circumstances in which one can be a secondary victim, including one being in proximity to the traumatic event, witnessing the traumatic event through unaided senses, and also having a close tie of love and affection to the victim in relation to the traumatic event. That is a crash course in psychiatric harm. If you want to know more about our lessons on psychiatric harm, go back to the previous videos where we've talked about psychiatric harm as the result of injury, the cases that are established therein, psychiatric harm which is pure, the delineation between primary and secondary victims, and the ways in which claims can actually be made for those particular incidents. They are all in the playlist for the Law of Tort. So, given that that's what psychiatric injury essentially is and how we divide psychiatric injury up, we have psychiatric injury, which is not pure, and then we have pure psychiatric harm divided between primary victims and secondary victims. Given that all of this is considered, how does employers' duty of care and employers' liability relate to and tie into all of these concepts? Well, the common law duty of care that an employer has will also extend to that of a duty to take care in the prevention of an employee who is suffering psychiatric harm. It's seen that there is no reason why, if there is a duty of care on the part of an employer to maintain effective work environments and to ensure that physical harm is not unduly incurred, that should also apply when it comes to psychiatric harm as a result. And the key case that we can see here is the case of Walker versus the Northumberland County Council from 1995. Now, in this case, we have an employer who had suffered from a nervous breakdown, an employee, should I say, who had suffered from a nervous breakdown as the result of an incredibly heavy workload. So they worked very, very hard. They had quite a lot of stress. They had quite a lot of work and a lot of deadlines on their plate. I'm sure all of us who have done their exams or who have worked in some kind of environment of that kind of nature would know the kinds of stressors and the kind of heavy workload that can exist in certain working environments. Ultimately, the result was that the employee had to take some time off. Upon returning to work after taking some time off, the heavy workload that was originally imposed on this employee had actually not been alleviated. And so what this had done is led to a second nervous breakdown, which was, of course, a psychiatric condition as a result of the heavy workload. So they had a heavy workload. They said, well, I need to take some time off. I'm having a nervous breakdown. The employer says, okay, go and take some time off. When they come back to work, this heavy workload was still there. And so as a result of which, no problem had been solved. All that had happened is that they were just going to have to do more of this heavy workload. It was held that the employer, who, while knowingly allowing the employee to work with a heavy workload, was therefore liable for the psychiatric harm that was suffered as a result. This is a very influential case, since what it did was represent a situation where an employer was liable for the inducement of psychiatric harm as the result of workplace stress. One of the very, very important cases when it comes to, and one of the very important incidents in relation to employment law more generally, is this idea of the inducement of psychiatric harm, which is the result of workplace stress. Workplace stress, of course, is a very, very, very important thing, a very, very key thing that exists and leads to quite serious mental and sometimes physical conditions, and can sometimes even lead to the deaths of individuals as the result of this kinds of stress. It can ruin a lot of people's lives, workplace stress. And so as a result of which, this is a hugely influential case because it places a certain amount of liability onto that of an employer for essentially allowing the inducement of psychiatric harm as the result of workplace stress. It doesn't, however, just like with ordinary physical cases of psychiatric harm, it doesn't suggest that any instance of workplace stress is the result of the employer. What this suggests here is that there was an amount of knowledge, at least on the part of the employer, in allowing the employee to work with such a heavy workload, and there was an acknowledgement that the employee needed to take some time off as a result of this heavy workload. But then upon that person returning back to work, this heavy workload had not changed, it had not been alleviated, and so as a result of which the employer would have been liable in the law of tort, in the tort of employer's liability for the psychiatric harm that had been caused.